Oyez, oyez, oyez. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you. Good morning. This is second day of our February term in East Tennessee in the Court of Criminal Appeals. The panel today to my right is Judge Robert Holloway from Columbia, and to my left will be Judge Robert Montgomery from Kingsport. And I am Kerwood Witt from Monroe County. Call our case, Mr. Clerk.
State of Tennessee versus Bruce Foster.
Argument is 20 minutes aside. Mr. Hedrick, as you well know, if you want to request a reservation of that time for rebuttal, you need to let me know that, so you can proceed.
Thank you, Your Honor. May it please the court, good morning. My name is Joshua Hedrick, here for the appellant Shannon Foster. With the court's permission, I'd like to reserve 2 minutes of my time for rebuttal argument.
Yes, sir.
In this case, Your Honors, Mr. Foster's conviction for second-degree murder should be reversed for 3 reasons. First, because it was error to instruct the jury on a duty to retreat in the absence of a nexus between the illegal conduct and the killing. And second, because of the error in admitting a photo of the decedent with his children in the absence of any controversy to which that evidence related. And third, because the evidence in this case is insufficient as a matter of law. As a matter of brief background, mostly aimed at the argument relating to the insufficiency and the photo of the decedent, this was a case wherein Mr. Foster's mother was involved in a romantic relationship with a man named Ray Knox. They had, according to Mr. Knox's brother, had a tumultuous relationship. And on the night in question, Mr. Knox and Ms. Foster were engaged in a physical altercation that Mr. Knox's brother described as worse than usual. Mr. Knox was intoxicated with a blood alcohol level of 0.227, and as we see from the evidence, beat Ms. Foster pretty severely. Mr. Foster was called to the scene by a friend of his mother who told him that his mother was being beaten. And when he arrived, he confronted Mr. Knox, who, if the court will excuse me, responded by saying, "Fuck your mama, she's a bitch and so are you." Mr. Foster and Mr. Knox then engaged in a physical altercation, and Mr. Knox's mother, Tammy, explained to the court that she called the police because, and I quote, "I know my son, Ray, and he gets real angry when he gets upset, and I couldn't hold him back. I knew I had to call the police because once he get like that, can't nobody stop him." And the incident escalated and resulted in Mr. Foster shooting and killing Mr. Knox. At the time, Mr. Foster was not permitted, he did not have a permit to carry a handgun. He was not a felon. He simply was not a holder of a handgun carry permit, and I think was underage for the ability to carry or possess a handgun. And that brings us to our first assignment of error, which is that it was error to instruct the jury on the duty to retreat absent a nexus between that illegal conduct and the killing. And the reason I restrict myself to that illegal conduct is because that is the only illegal conduct which the trial court found. If we look at the transcript at volume 15 at 866 to 867, we see that the trial court made a specific finding and was asked specifically to just set forth its finding about the unlawful activity under the Perrier analysis And the trial court found that the unlawful activity was carrying a firearm without a permit. The trial court did not find that the unlawful activity was a trespass, and the trial court did not find that there was a firearm. The unlawful activity was the use of a firearm in a dangerous felony. Those were the findings of the trial court, and this court respectfully should give deference to those findings. The difficulty is that under our current law, as it stands after the 2007 amendment, there's no duty to retreat unless a person is engaged in unlawful activity or is not in a place where they have a right to be. So it's really stated in the negative, but if you're in a place where you have a right to be and you're not engaged in unlawful activity, you don't have to retreat. Now, the difficulty comes with an offense like Mr. Foster's, which is essentially a status offense, as this court observed in Booker. And the analogy that I would draw for this court is, imagine that someone is driving, has a suspended license, and is driving their car, even though they have a suspended license, stopped at a stoplight, and an assailant runs up and carjacks them, pulls out a knife, puts it to their throat, and yanks them out of their car, and that man draws a weapon and shoots his carjacker, shoots his attacker, saving his own life. But he's driving on a suspended license, so he doesn't get to do that. He had a duty to retreat. That result is the result which the state urges. And I would suggest to the court that that result is the type of result that our law would not countenance. And that Perrier, in the Supreme Court's decision in Perrier, which did not answer this question, found this particular question unnecessary to its analysis and did not provide an answer, leaves it to this court to interpret. In this instance, because he was a juvenile in possession of a handgun, it is a status offense, and as a status offense, did not provoke this incident. There is no nexus between that and this incident. That is, Mr. Knox was not shot because Mr. Foster was carrying a weapon. Mr. Knox was shot because he assaulted Mr. Foster's mother, and that led to a dispute between he and Mr. Foster.
Well, as a question of fact,
yes, sir.
Mr. Knox was shot because there was a pistol on the scene that fired the shot that killed him. How could there not be a nexus between the possession of that pistol and that firing that shot that killed the victim?
Well, I certainly agree that in any shooting, there must first be a pistol, and that were it not for the pistol, there wouldn't be a shooting. What I urge the court to find is that there must be some connection between the illegal activity and the difficulty, that the difficulty was a consequence of the illegal activity. That avoids the problem we have with my carjacker example. So to give a counterexample, if you are a burglar and I draw a weapon on you in my home, you can't claim self-defense because you're engaged in an unlawful activity that resulted, that set the acts in motion. If all we're saying is that anytime you have, that just having the pistol, even though that's not the cause of what happened, that leaves us open to the carjacker example where someone is unable to use self-defense without retreat because they're engaged in some unrelated criminal conduct. I realize that this is more related, but the pistol is not what started this difficulty. Were it not for, you could apply the but-for analysis, like a but-for analysis to that pistol, but you have to go back further. If there were no disagreement between the two men, if there were no assault on Mr. Foster's mother, the pistol never comes out of his pocket. He never goes over there to begin with. It's not the existence of the pistol that caused this ruckus. And therefore, it should not bar him, or it should not require him to retreat. And that's our suggestion with respect to this nexus, that it must be the cause of the underlying difficulty. Second, it was error in this case to admit the photograph of the decedent with his children in the absence of any controversy. As this court is well aware, to be admissible evidence must be relevant, and that means it must address itself to the resolution of a dispute. In this case, there was no dispute which this photograph resolved. The only issue at trial, throughout the entirety of the trial, was whether Mr. Foster acted in self-defense. And there was no dispute, because it is a self-defense argument. Inherent in a self-defense argument is the admission that Mr. Foster shot and killed Mr. Knox. The jury was told from the very moment they entered the courtroom that Mr. Foster shot and killed Mr. Knox. There was never a dispute that that was the case. And when asked what the purpose of this photo was, in the record, volume 3 at page 30, the state was unable to provide any purpose for this photograph. On appeal, the state for the first time suggests that it was used to establish the identity of the victim, which was not in contest. No one disputed that Ray Knox was the man who was shot. And then the state secondly urges that it was relevant to establish the size of the victim. But the court can look at Exhibit 1 and see that this photograph doesn't do that, because it has no scale. All it does is establish that Mr. Knox is larger than a child, which is not helpful in resolving any dispute about Mr. Knox's size. It is a photograph of a man with his children, and it is used for no purpose other than to play on the sympathy of the jury, and that's why at trial the state was unable to give a reason for its admission. When we look at our Supreme Court case law and we see State v. Adams, for example, 405 Southwest 3rd, 641, specifically at 657, the Tennessee Supreme Court from 2013, we see the Supreme Court say, and I quote, "Over the years, this court," being the Supreme Court, "has consistently cautioned the state against the introduction of such photographs as evidence because they typically lack relevance on the issues on trial and because of their potential to unnecessarily arouse the sympathy of the jury." And I suggest to this court, respectfully, that the reason the Supreme Court has found it necessary to consistently caution the state over the years about introduction of this type of photograph is because the state continues to do it, knowing that it's likely to be harmless error. So it's a good gamble. It's a good strategy. It rarely results in reversal, but is an effective tool to play on the emotions of the jury. So I suggest to the court that the Supreme Court has repeatedly cautioned, and until a reversal occurs, we'll have to continue to caution. In this case, there was nothing answered by this photo. It was not relevant. It was a play on sympathy, and it should not have been introduced into evidence, particularly when the trial court's ruling on these objections consisted of the trial court announcing that it has and will continue to permit one photograph, which respectfully is not an analysis of the rules of evidence and should not have deference. This is not an appropriate way to litigate a case and should be found to be error. Third and finally, the evidence in this case is insufficient as a matter of law to convict Mr. Foster of second-degree murder. Now, Mr. Foster approached trial with a self-defense argument, and as we can see, the jury rejected the claim of self-defense. And taking the evidence in the light most favorable to the state, there is, of course, as a matter of law, it's possible that a jury could reject the self-defense argument. However, under these facts, this evidence cannot, as a matter of law, establish more than a voluntary manslaughter. This is a case, the facts of this case would be an excellent way to explain provocation. A man is called and told that his mother is being beaten by her boyfriend. He arrives to find chunks of her hair torn out. A man, angry, drunk, screaming, cursing and spitting on his mother, cursing and spitting on him. And he says to this man, "Did you assault my mother?" And the man says, "Excuse me, Your Honors," but the man says to him, "Fuck your mama. She's a bitch and you are too." If I had been called upon to explain to a law school class what's a good example of provocation for voluntary, I think this would be a good description.
Do you think?
I'm sorry.
Do you think the comment that the victim made that you just quoted falls within the category that we've traditionally referred to as fighting words?
Absolutely, I do, Your Honor. I absolutely do, and I think that it's compounded by the description of his mother. When Mr. Knox's mother is asked, why did she call the police? She says she called the police because I knew I had to, because once Mr. Knox gets like that, can't nobody stop him. Mr. Knox was in a mood to fight. He was intoxicated. He'd already beat upon his girlfriend. He'd already injured her. There was some disagreement at trial about whether Ms. Foster's hair had been torn out in this incident or in a prior incident. And for the purpose of this analysis, I suppose we have to draw that inference to the state's, inuring to the state's benefit. But even if we do that, Mr. Foster is operating on what he's been told. And he's been told his mother was in a fight and his mother was beaten and he sees her with an injury and he doesn't know whether that was an earlier incident or not. He has reason to think that this man has just beaten his mother. And that reason to think this man's beaten his mother is confirmed when he confronts the man. And instead of the man saying, "I didn't touch your mom. We're okay. We were just having an argument." The man reacts in a way that would, if Mr. Foster weren't already upset about his mother being beaten, would be upsetting, would cause a reasonable person to lose control of their emotions. And for that reason, Your Honor, as a matter of law, the evidence is sufficient only for voluntary manslaughter. I appreciate
your reserved time.
Yes, Your Honor. I appreciate the court's time, and for those reasons, I ask that the judgment be reversed. Thank you, Your Honors.
Mr. Hedrick, let me ask one question before we go to the state. I'm sorry I've waited so long, but it goes back to the duty to retreat. So in this case, we have the victim beating up the man's mother and the words said. And then, if I read the facts correctly, the victim knocked the defendant to the ground. And the defendant retreated to his car.
Yes.
And the victim followed him to his car, and I assume the defendant thought he was going to be attacked again and shot him. Is that sort of the correct facts?
That's exactly right, Your Honor.
And the gun, was there proof that it was on his person or in the car or anything like that?
There was disputed proof. The mother of the victim testified that she saw him holding the gun when he was outside the car at the beginning of the difficulty, right? But he was holding it down at his side. Now, the father of the victim When asked, why were you upset about him being on your property? He said, because I didn't want him there, and didn't mention any weapon. So the father of the victim, when asked, what was wrong with him being there, said nothing about the pistol. The mother said she saw a pistol. The father doesn't appear to have seen the pistol. Mr. Foster's testimony was that the pistol was in the car, and he did not have it out until Mr. Knox approached him in the car, and that's when he took it from the glove box. Thank you, Your Honors.
Okay. We'll hear from the state.
Good morning, Your Honors. May it please the court. My name is Garrett Ward. I'm here this morning on behalf of the state of Tennessee in the matter of State versus Shannon Foster. Here on direct appeal, Mr. Foster raises 3 challenges to his conviction for second-degree murder. I'll address these issues in the same order as opposing counsel did at oral argument. Firstly, Your Honors, the defendant suggests that the trial court erred in giving a duty to retreat instruction. Tennessee statutory law holds that a person does not have a duty to retreat prior to exercising self-defense so long as they are not engaged in illegal activity or in a place where they have no right to be. So if a person is engaged in illegal activity or they are somewhere where they don't have a right to be, they have a duty to retreat prior to exercising their right to self-defense. It seems to be largely undisputed in this case, Your Honors, that the defendant was engaged in illegal activity at the time he shot and killed the victim in this case. The victim was underage at the time of this shooting and in possession of a handgun, which is prohibited by Tennessee statute. And there appears to be very little dispute about this. So just under the plain language of the statute itself, it would appear that the defendant's conduct being illegal activity means he does have a duty to retreat, and that he needed to exercise that duty prior to exercising his right to self-defense.
All right. Mr. Ward?
Yes, Your Honor.
He did retreat, correct?
Yes, it appears that he backed up and was in his car at the time
So he retreated to his car and was attacked, or thought he was going to be attacked again there, correct?
Your Honor, there's some dispute in the proof about what exactly the logistics of this fight between Mr. Knox, the victim, and Mr. Foster were. The victim's mother, Mr. Knox's mother, testified that the 2 men were arguing, but that there was never any physical contact between the two. She, while the defendant testified, and I believe his mother testified as to being charged at by the victim, this testimony was not mirrored in the testimony of the testimony of the victim's family members. So there's some dispute, I'd say, in the proof at trial about where exactly this fight took place, if Mr. Knox pursued Mr. Foster back towards Mr. Foster's car. But Your Honor, it is true that at least in the testimony of the defendant, he fought with the victim. They broke away. He got back in his car, and then the victim charged at him, and that's when he shot. That's what the defendant claimed at trial. So to that end, Your Honor, it does appear that the defendant did make perhaps some attempt to retreat, potentially satisfying this duty, but that would not, in and of itself, mean that the trial court should not give the duty to retreat instruction in a circumstance like this, where the plain language of the duty to retreat statute suggests that it should apply. Now, I'll address Your Honors. The defendant is suggesting this court read into duty to retreat statute a nexus requirement. At the time of this trial, and indeed now, this is a bit of an unsettled question of law in Tennessee jurisprudence. The Supreme Court in Perrier specifically declined to answer this question. Since then, a panel of this court in State versus Booker has suggested that the duty to retreat statute does have a nexus requirement in it. That there must be some sort of nexus between the illegal activity at issue in the case and the exercise of self-defense. And Your Honors, just for the sake of argument, I'll for now presume that this nexus requirement does exist. I'd suggest to this court that there's a strong nexus in this case between the illegal activity of illegally possessing a firearm and ultimately using that firearm in self-defense. Without the exercise of self-defense, the shooting simply could not have occurred without this illegal activity. I'd suggest there's a strong nexus between illegal possession of a handgun and the ultimate use of that handgun. One cannot seem to exist without the other in this scenario. Opposing counsel likens this to somebody driving on a suspended license, and suggests that the state's argument, if taken to its logical conclusion, would be that, well, somebody driving on a suspended license can't defend themselves from a carjacker. But I believe just by the face of that example, it's clear that that's more attenuated than the driving on a suspended license, and an ultimate carjacking is more attenuated than illegally possessing a handgun, taking that handgun to the scene of a man that you intend to argue with, and then using that handgun, perhaps in self-defense, to kill this person. And in a circumstance like this, where the defendant possesses the handgun illegally, takes this handgun to the scene where by all accounts and even by his own admission, he's intending to confront the victim. But there's a nexus. There simply is a nexus here between the illegal activity and his ultimate exercise of self-defense.
Mr. Ward?
Yes, Your Honor.
How old was the defendant at the time of the shooting? Do you know?
I believe he was 17, Your Honor.
All right. And the only reason he wasn't a convicted felon,
no,
the reason it was illegal is because he was a juvenile?
Yes.
The reason it was illegal to possess the gun?
Yes,
so
sir.
if he'd been a year older, he would have had no duty to retreat. Is that correct?
Yes, Your Honor. If he had not been in I mean, perhaps there would have been questions about handgun permitting and carry permits and things like that. But yes, in general, Your Honor, had he been in compliance, had he not been violating the statute that prohibits people of his age from possessing a firearm, he would not have had the duty to retreat.
Okay.
But in this case, Your Honor, at the time this occurred, he certainly was affected by the statute prohibiting juveniles from possessing and carrying handguns. And I would urge this court to draw a nexus between, if this court is inclined to think that the statute does contain a nexus requirement, I would urge this court to conclude that in a circumstance like this, there is a nexus. Briefly, Your Honor's defendant did suggest that, well, perhaps this is a status offense, and that status offenses simply won't really ever establish a nexus. That's an argument the defendant advanced in his brief and alluded to here at oral argument. And I would point this court to what's perhaps the seminal case on this issue, State versus Perrier. The illegal activity in that case was illegal possession of a handgun. was something that the defendant would presumably refer to as a status offense. And although the court in Perrier did not resolve explicitly the nexus requirement issue, I do think the Supreme Court's decision in Perrier that the statutory duty to retreat does apply to somebody that is illegally possessing a handgun, albeit in Perrier it was the felon in possession statute rather than the juvenile in possession statute, which is at issue here. But I would draw a line from the Supreme Court's reasoning in Perrier that the illegal activity there is illegally possessing a handgun, and the court had no trouble there concluding that this sort of illegal activity, unlawful possession of a firearm, did trigger the statutory duty to retreat, and I think the same should hold true in this case. Secondly, Your Honors, the defendant suggests that the trial court erred by introducing a photograph of the victim as a life in being. Your Honors, there is a Tennessee statute at issue here which suggests that an appropriate photograph of the victim shall be admissible evidence. That photograph does not obviously preempt other rules of Tennessee evidence, or the statute doesn't preempt other Tennessee rules of evidence.
Were there any photographs that were submitted or that were not allowed that didn't show the victim holding his small daughter in his arms and standing by his other daughter?
To my recollection, Your Honor, this was the only photograph offered at trial.
So they really wanted to show a father in being, correct?
Your Honor, the testimony around the introduction of this photograph does not reflect that was the state's intention. The state here did, choose to offer a photograph that sort of put Mr. Knox with his best foot forward, as Mr. Knox himself could have done were he to present himself at trial. Were he to not have died, he could have presented himself with his best foot forward before the jury. He was not able to do that, so the state attempted to do that and chose to do that with this photograph. The defendant at trial raised a relevancy objection to this photograph, and I'd suggest that this photograph is relevant for a couple of reasons. One, that the Tennessee Supreme Court has recognized that the state is required in all homicide cases to establish the identity of the deceased. This photograph would speak to that. This photograph, perhaps more importantly in this case, Your Honors, would also be helpful in evaluating the defendant's self-defense argument. As opposing counsel, I believe would agree with me, that's truly the only dispute in this case. There's no dispute that the defendant shot and killed the victim. The only question is, was it an exercise of self-defense or not? This photograph, just from looking at it, is clear that the victim is a smaller man. He's slight statured. He's rather lean. Certainly a photograph of the size of the person whom the defendant is claiming to act in self-defense of is relevant, at least to some extent, in evaluating the reasonableness of his self-defense claim.
Have you come across any cases where this court or any court has approved of the use of a photograph wherein children were pictured, children of the victim were shown? Have you come across any cases where we've accepted that?
Yes, Your Honor, I have. I believe in the Nesbitt case, which was a Tennessee Supreme Court case, similar style photographs were admitted.
Okay.
Tennessee Supreme Court has also recognized in State versus Adams that these sorts of photographs are rarely of the type that require a new trial. So even should this court conclude that there was no relevancy issue here, I would suggest that the admission of this photograph, were it irrelevant, would be harmless. The defendant makes in his brief a 403 objection. That objection was not made at trial. So to the extent this court wishes to evaluate this photograph under the 403 analysis, it would solely be plain error. And I would suggest to this court that he cannot establish the plain error requirements here for much the same reason, for many of the same reasons that this photograph was relevant. It had probative value. Tennessee Supreme Court has indicated that these photos are not generally of the type to require a new trial. So substantial justice here would not require consideration of the error, nor is there sort of a clear and unequivocal breach of law simply by admission of a photograph of a victim that also has one of his children in it. So for all those reasons, the 403 argument advanced in the brief is unhelpful to the defendant ultimately. Lastly, Your Honors, the defendant suggests the evidence here was insufficient to support his conviction, and what he seems to truly be attacking is the evidence the state put on to rebut his self-defense claim. I suggest, Your Honors, that this self-defense claim is largely a case of Group A's word versus Group B's word. The defendant and his mother at trial testified that they went to the victim's house. They confronted the victim. The victim and the defendant got in an argument. This argument got physical. The victim knocked the defendant to the ground. The men sort of separated. The victim charged the defendant. The men separated again. The defendant got in his car, and then the victim charged yet again. And that only at the conclusion of this sort of second charge did the defendant shoot the victim. That was the testimony at trial from the defendant and his mother. The state's witnesses at trial both testified that they never saw any physical contact between the two. There was certainly an argument, but the victim's mother and his stepfather, who both were witnesses to this episode, testified that they did not see any physical contact between the defendant and the victim. And notably, Your Honors, in prior descriptions of this altercation, the defendant in multiple interviews with law enforcement, the defendant's mother did not make any mention of some sort of physical attack. She recounted this altercation numerous times to law enforcement, and on numerous occasions did not tell law enforcement that, well, the victim charged my son and threw him to the ground and then charged him again, and that's when he shot. That's not what she told law enforcement. That is what she said at trial. Similarly, the defendant gave an interview with law enforcement where he explicitly downplayed the physical nature of his altercation with the victim. He describes it as a scuffle that's generally not terribly physical, maybe some pushing and shoving. So both the defendant and his mother, their description of the seriousness of the physicality of the interaction between the two men is lower in pre-trial descriptions of the altercation, and then very high at trial. So the jury has these inconsistent descriptions from the victim or from the defendant and his mother. They have the state's witnesses saying there was no physicality between the two, and then the trial testimony of the defendant and his witnesses suggesting no, this attack was quite physical. Seems the jury just rejected the testimony of the defendant and his mother in favor of that of the state's witnesses, which makes good sense given the inconsistent nature of the defendant and his mother's recollection of this attack.
So was it the state's theory that the defendant retreated to his car because they had worked their differences out and he was no longer fearful that the victim would beat his mother up anymore? Why did he go to his car?
So, Your Honor, the proof at trial showed that this argument was, while non-physical, was heated. And both the defendant's mother and the victim's mother said, "Look, we wanted to, separate the two. We didn't want there to be any physical violence. So we got in between them. I was getting my son back into my house." That's what the victim's mother said. And the defendant's mother similarly testified that she was wanted to get her son sort of out of the situation. So it seems he retreated to the car sort of at the behest of his mother. But I would suggest, Your Honors, that the descriptions of the event offered by the state's witnesses would be sufficient to overcome the defendant's self-defense theory.
That concludes your time, General.
Thank you, Your Honor. If this court has no further questions, I would ask this court to affirm the judgment of the trial court.
Thank you. In rebuttal, Mr. Hedrick?
Briefly, if Your Honor, please. Usually it's not until a day or two after the argument that I think of an answer to Judge Witt's questions. But in this case, I'd like to suggest, when you had asked earlier about whether the gun in this case was the cause, that were it not for the gun, there would be no shooting, I would offer one last analogy for the court, and that is a case, imagine a scenario where a 16-year-old is at home and an armed burglar breaks in. The 16-year-old retrieves her father's pistol and shoots the man in self-defense. Well, as a juvenile, she's not permitted to possess that handgun, but she should not have a duty to retreat. And I think that is probably the better example of why we should look to the cause of the difficulty and not just the status of the person with the weapon. And I thank you all again for your time, Your Honors. Have a good afternoon. And for those reasons, we ask that you reverse the convictions.
All right. Thank you. That concludes the argument on this case, and the court will be in recess until 10 o'clock.
The Honorable Court is now in recess until 10 a.m.